This is a presentation on some key considerations pertaining to juries and criminal trials in the state of Victoria. The first thing to point out is that if we are talking about a trial under Commonwealth law, then pursuant to the Judiciary Act 1903 Commonwealth, Section 68 subsection 1 and Section 77D subsection 2, state law, in this case Victorian state law, governs juries to the trial and conviction on indictment of Commonwealth offenders in Victoria. And if we're not talking about a trial under Commonwealth law, then we are talking about a trial under Victorian law, and we will get to that shortly. Okay. Now, it's also worth pointing out that pursuant to the Jury Exemption Act 1965 and the Jury Exemption Regulations Act 1987, specific categories of Commonwealth employees are exempt from jury service, and also, very importantly, a unanimous verdict is required in Commonwealth jury trials, and we will revisit this shortly. So, let's assume that we are talking about a trial under Victorian law, and we will bear in mind this caveat of Commonwealth law. Well, the first question is really about jury selection. So what does that all involve? Well, when we're talking about jury selection, we have to, start with people who aren't going to be on the jury so that we can whittle down to those who will be on the jury. And the Juries Act 2000 in Victoria gives three classes of people who don't serve: those who are ineligible, those who are disqualified, and those who are excused. So let's look at those people who don't serve on a jury in Victoria. Those who are ineligible include the police, lawyers, corrective services personnel, and persons with a disability that prevents jury service. So I assume that would probably be more of a mental disability rather than a physical disability, but that's the wording of the schedule. Then we go to people who are disqualified. So it's a lengthier and more detailed list, but let's run through it. So someone who's convicted of one or more indictable offences and sentenced to 3 or more years in jail, someone who's detained under a hospital security order for a period of 3 years or more, someone who within the last 10 years has been imprisoned or detained under a hospital security order for 3 months or more, someone within the last 5 years who has been imprisoned or detained under a hospital security order for less than 3 months, someone within the last 5 years who has served a sentence of imprisonment by way of intensive correction order, suspended sentence, youth justice centre detention, youth residential centre or community-based order, someone who within the last 2 years has been sentenced for an offence or released on an undertaking, someone who has been charged with an indictable offence and who is on bail or who is remanded in custody in respect of any offence, or someone who has been declared bankrupt and has not obtained a discharge. Also, excused from jury duty are people who are very, very sick, illness, people suffering substantial hardship, which includes financial hardship, people who have to care for dependents, and people of advanced age. So age is not a barrier in itself to jury duty, but that can be grounds for excusal if it is relevant or pressing. So that's a quick run through of people who don't serve on juries in Victoria. So everyone else who is an adult and who is a citizen and so on, it can serve on the jury. It's really very straightforward. And let's go to this topic of impanelling the jury. So we're talking about challenges for cause and also the Crown's right to stand aside. So when the jury is being selected, a whole lot of people, a jury pool is brought to the court, and both the defence and the Crown have the opportunity to object to potential jurors. So the accused has if we're talking about a single accused, he has the right to object to 6 potential jurors. If there are 2 accused, then each one has 5. If there are 3 or more, then each one has 4. Similarly, the Crown has the right to object to potential jurors, and it comes in 2 flavors. Firstly, the Crown has the right to stand aside, which is it can object to a potential juror basically without giving much justification, and it has a set number depending on the number of accused we're talking about. And the Crown also has an unlimited number of challenges for cause. So challenge for cause is different from right to stand aside, and let's look into that a little bit more deeply. So the right to stand aside is basically just a very quick way of weeding out or reducing the likelihood of a potential juror to stand. And if the Crown exercises this right to stand aside, then the person is not excluded per se from serving on that jury, but is rather taken to the back of the queue and is very unlikely to be selected again. And there are guidelines in that the Office of Public Prosecution has published. I won't go, actually I'll go through them, why not? So the idea is that underlying all of this, the prosecution's task is not to select, specifically not to select a jury that will be favourable to its case, but rather to do its best to ensure that the jury will do its job, which is to hear the evidence and be as impartial as possible, or as impartial as humanly possible. So some of the the guidelines include section 634. So if we're talking about the right to stand aside, that can be exercised if a potential juror is seen speaking to a party who is known or related to a participant, if there's a reasonable basis for apprehending bias, if there's a clear expression of hostility towards the procedures, if the juror exhibits behaviour demonstrating unwillingness to participate, or is incapable of discharging his duty by reason of some obvious disability. So if we're talking about a trial with a lot of visual evidence and the potential juror is blind, then that is something that will trigger the exercise of the right to stand aside. Now, if we're talking about a challenge for cause, that's something more serious than obvious, than easy attributes by which the prosecution might object to that person serving on the jury. And as a matter of basically of procedure, the Crown should really use up all of its rights to stand aside, its reserve of the exercise of the right to stand aside before mounting challenges for cause. So an example of a proper basis for challenge for cause would be that the potential juror is a relative or is very, very well known to one of the parties. And of course, when we're talking about impaneling the jury, all of these issues have to be tried by the judge before whom the jury is being impaneled. And when you are mounting a basis, when you are mounting a challenge for cause, then you have to have a proper basis, as I said here, and there are guidelines on that, which include never using the right to stand aside for sex, age, ethnicity, etc. Those are not a proper basis. A proper basis would be something that indicates very strongly that the juror is not going to be impartial, basically. And if you do have a proper basis, then it has to be clear, undoubted, and capable of being proven to the judge. So if you mount a challenge, then you have to back up that challenge. And overriding all of this are 2 principles. One is that it's the right of the accused to select the most favourable jury possible. That's his right, and that's and there's absolutely nothing wrong according to our system of the for the accused to use his rights to maximize his chances of getting a favorable trial, whereas the Crown must not be seen to select a jury favorable to the prosecution. So sorry for going about this in a slightly roundabout way, but there are lots of things they don't really flow very easily. Okay, so assuming that we've got a jury impaneled and we've got our 12 or so, if we have a long trial, then more than 12 jurors, up to 15, can be impaneled. So you have your 12, and then and then the trial judge will take into account that it looks like it's going to be long and can impanel a few more, because there's a certain minimum of jurors who have to be there by the end of the trial in order for a verdict to be given. Okay, sorry for that delay. Okay, so let's say we go through the trial and then a verdict is delivered. Well, then we have to look at a few things. First of all, if the verdict has been delivered, we have to look at questions of miscarriage of justice, and also if we have a long trial and there are more than 12 jurors, then at the end of the trial, or before the verdict is delivered rather, there will be a ballot to select 12 jurors out of the remaining 12 plus, and also there's a question of whether a unanimous verdict is required or a majority verdict. So the minimum number of jurors required for a majority verdict would be 10, 10 jurors in total, and the majority verdict requires 9. If you have 11, then you need 10. And if we're talking about an offence that requires a unanimous verdict, that's going to be a trial for murder, treason, or a serious drug offence as listed in the relevant legislation, or of course a Commonwealth offence. So let's jump in and explore this question of miscarriage of justice as far as juries are concerned. So there are basically three main respects in which an argument for miscarriage of justice can be made. The first is material irregularity, and a rather unusual case of material irregularity was Queen against Young in 1995, QB 324, where the night before delivering the verdict, the jury used a Ouija board to decide the verdict. They tried to contact the spirit of the deceased, and the deceased said, apparently, as far as the jurors were concerned, that there should be a certain verdict delivered. At any rate, it came to light that the jury had used this Ouija board, and it was held that there was a material irregularity and a new trial was ordered on appeal. Another question might be that a juror did not sufficiently comprehend the language that the trial was conducted in. So here we have an example, I think it's from Thailand, of Ras Bahari Lal against the King Emperor, 1933, where it came to light that one of the jurors did not actually speak English, or did not speak English very well. The trial was held in English, and it was held that the effect of the juror's inability to understand the language was to deny the accused person an essential part of the protection afforded to him by law. So if by some strange twist of circumstances you find that you have someone in the jury who doesn't actually understand the language in which the trial is being conducted, then you need to replace that juror or order a new trial very, very quickly. Extremely unlikely to happen, but I suppose stranger things have happened. Then finally, we're going to talk about jury bias for or misconduct as being grounds for appeal, and this is where it gets tricky. The appeal's probably going to be dismissed if we follow the English example, as we saw in the case of the Queen against Mirza, who was a Pakistani man convicted of rape, multiple counts of rape, and his defense lawyer appealed the conviction, saying that the jury passed notes and seemed to indicate that they were prejudiced towards this man. It was argued that there was an argument of racial prejudice, and the appeal was dismissed in this case because it was made clearly after the conviction, and it was held that jury conduct of this kind can be an issue, but only if it's raised during the trial, not afterwards. But I think in Victoria we might it might be a little different. So those are three highlights of miscarriage of justice when we're talking about juries: material irregularity, juror comprehension, and jury bias or prejudice. Generally speaking, there's great resistance to the idea of contesting the bias or raising the issue of prejudice of the jury once the jury's been selected and the trial's underway, because otherwise it opens up a can of worms, maybe Pandora's box, we might say. But that's it's worth bearing in mind. And then finally, to go back to unanimous verdicts, if we refer to the Jury Act, section 46, subsection 4, it lists the very serious drug offences for which a unanimous verdict is required in Victoria. Obviously murder and treason are required, and of course indictable federal offences. And if we have a majority verdict, then unless a unanimous verdict is required, a majority verdict of 9 out of 10 or 10 out of 11 or 11 out of 12 would be acceptable. So I'll just add that last one. Okay, so that's pretty much an overview of how we go with juries. It's not terribly complex. The other part of deliberations of juries really has to do with these more philosophical debates about whether we should have juries, whether we have 12, what kind of juries, all that sort of stuff. But as far as the procedure goes, it's pretty straightforward. The law that governs the trial is state law in Australia. There are very clear procedures about the selection of juries, and there are just some pretty straightforward guidelines for impaneling. And then once the trial is underway, trial concludes and a verdict is delivered, it's only going to be in very unusual circumstances that we really talk about a miscarriage of justice, and it's also a pretty clear question of procedure whether you need a unanimous verdict or you can suffice with, or whether a majority verdict will suffice. So anyway, that's my little presentation on juries in criminal trials in Victoria. I hope that this has been helpful to you. Before long, all of this stuff will make its way to my blog, tabulalex.blogspot.com. Please feel free to comment down below. Let me know if this has helped you, or if I've got anything wrong, and thanks for watching.